Well, welcome to Chapter 12. We're moving on to sexual assaults, rapes, prostitution, and related crimes. Of course, this is going to be a sensitive subject matter, so be prepared for the use of certain language, and also be aware that we'll be using scenarios here that possibly might be offensive to people. So just be aware. We're using them in an educational manner to address them as crimes or not crimes, depending upon whether they meet the statutory or case definitions of what's going on. Okay, so we've got our learning objectives there that we'll just move on, and we'll start with sexual relations in the United States today. By relations, I'm referring to sort of any sexual contact or sexualized contact. And these sexual relations can become a crime in a number of different circumstances. First and foremost, the most obvious one is if it is an act that lacks consent by one party. If they're also conducted with a minor who is incapable of legal consent, even if the minor was to give consent, the law does not recognize the authority of the minor to do that, and that would constitute a crime. That would typically be called statutory rape by the general public. If they're conducted with someone who is mentally deficient or an adult incapable of consenting, here we're talking about people, if we're going to use the rather crude measurement of IQ, or if we're going to measure someone who has a mental state, a temporary mental state like intoxication. If they're performed in public, that's kind of self-explanatory. If they're performed for profit in a quid pro quo situation, that can be crime both for both participants, the one who purchases the sex and the one who sells the sex. If they're between a therapist and a patient in violation of that state's law, and that therapist, by the way, many states, including North Carolina, will look at any custodial situation, whether it's a physically custodial situation like sex between an inmate and a guard in a prison, or whether it's between a doctor and a patient or a nurse and a patient in a hospital or a medical center, or if you've got someone in a position of great trust and authority like a psychologist or a psychiatrist, you can see how that could be an abusive relationship, and it can be criminal. So again, we're going to focus in on what I'm most familiar with, which is going to be North Carolina. And if we look at that, we have two broad categories when we're looking at I would say, kind of the classic sex crimes. The rape and sexual assault. Now, this can cause some confusion for my students, how we define these. But basically, the way to think about this in North Carolina is rape is anything that is sexual intercourse, and sexual assault is everything else. Okay, there are also different factors that can cause crime in a sexual relation. The age difference between the parties, that would bring up our statutory rape issues again. The consensual issues, is the person capable of giving consent? Did they give consent? Was there harm done? So physical injury. Is it an exploitive relationship? Are we producing something that is sexually obscene? Okay, so let's take the first real broad categories here, and that's going to be the rape or the sexual assaults. Now, historically, we have, of course, the development of the common law. And since the common law developed in medieval England, it should be pretty unsurprising that this is a misogynistic or male-centered definition. And, rape is tied up in a lot of this male hierarchy of, valuing the woman as she represents a value to the man, to the family in particular. And it was really seen that women were essentially an extension, almost a possession of the male, the person in charge of the family. And to rape the woman was, an injury to the man as well, as strange as that sounds today. But historically, common law rape was a non-consensual relationship accomplished solely by force or threat of force. Now, today, rape can be oral, it can be vaginal, it can be anal, it can be accomplished by a penis, a finger, a tongue, or a foreign object. Now, many states continue to use the term rape, but they bring a lot of things into it that classically were not seen as rape. I think you can kind of look at it this way. In the past, we thought of rape just as vaginal intercourse. And as we became more enlightened, more understanding, we broadened that definition to include all types of sexual contact. We also began to look at aggravating factors, things that might make it worse. Did you use a deadly weapon? Were there multiple parties involved? Did you transmit a sexual disease? Was your victim very young? All of those are aggravating. They make it worse. All right, so let's take a quick look to clarify this at North Carolina rape law. Okay, we're going to find this in North Carolina General Statutes 1427.21 and 14.2722. And these are, the roots of these are very, very old statutes. And you'll notice that the first thing we've done in North Carolina is we've defined rape very narrowly. We decided that we will take incidents of rape and highlight it. And we'll put all other sexual contact in a bucket called sexual offense. So rape has this narrow meaning. It is the vaginal penetration, presumably by a penis, the slightest contact. So rape is only going to occur if there's a vagina and if there's a penis. That means there's no rape technically in North Carolina if the contact is oral, or if the contact involves anal, or if the contact is between two men or two women. Now, those are still offenses. Let me emphasize that, and when we get to sexual offense, we'll see that. But we then take this vaginal penetration, we divide it into 2 degrees. We have first-degree rape, which is among the most serious crimes you can commit in North Carolina. And the minimum sentence there, you'll notice, is 144 months. So the minimum sentence you're going to get for something like that is 11 plus years. And you can get a sentence up to life. To make it first-degree rape, you have to have that first component. There is a vaginal penetration by penis. And the party who did this used a deadly weapon or a threat of it, or they committed this act with multiple parties, to use a common law or a common term. It was a gang rape, or you inflicted serious bodily harm. Now, obviously, every rape has a trauma and harm associated with it. To make it first-degree rape, we're looking at something beyond that, something more serious, even though obviously the trauma associated with every rape is serious. We're looking at a next level event. Second-degree rape, which runs from 44 months to 182 months maximum. So, it runs from a little over 3.5 years up to, 15. And it has a action. Again, you're going to have the vaginal penetration by force, or if the victim is helpless, so they're incapable. Let's suppose they were bedridden or physically unable, or if they were mentally disabled, or if they are physically incapacitated. Those would all be examples of second-degree rape in North Carolina. Now, as I said, there's a lot of other sexual contact, sexual relations, as your book talks about it, that don't fit into vaginal penetration. So we bundled them all together in North Carolina under sexual offense. So sexual offense in North Carolina is identical in its penalties, but it simply covers the other actions. So again, anything other than vaginal penetration by a penis, we have first and second degree sexual offense in North Carolina. The penalties are identical to first degree rape and second degree rape, but it covers acts like cunnilingus, fellatio, analingus, and anal penetration. All right, sex crimes. The term sex crime is a very broad classification. One of the things that starts to happen is as the 19th and 20th century progress, we have more of an understanding of the role of non-consensual, of underage, of sexual contact that in the past was, to put it charitably, excused. And now we realize that it is criminal behavior, or we've criminalized it. So we're talking a very broad range of things here, from very serious offenses to private activity between consenting adult. We're going to make some of those criminal. Now, non-consensual sex is virtually always a crime. It's almost impossible to construct any scenario or any situation where one party didn't want to have sex, didn't consent to the sex, and the other party compelled them to, and it not be a crime. Often, we also have the idea of the age of consent. Now, under the law, it is a crime to have sex with a child, and usually we're going to say that, of course, below the age of infancy, 1 to 6, 1 to 7, that's always a crime. And then up and through your early teens. Now, at a certain point, we have to say, all right, you're old enough now to consent to sex. And sometimes that consent can be at a very young age. And you'll notice it says, under which it's a crime to have sex with a child under a specified age, usually 13 to 16. And you're probably saying, well, how could you possibly have sex with a 14-year-old? Well, you have to consider that there are states that allow very early marriages. And if you were in a relationship where that party consented to marry you, and that party was under a certain age, under the age of 16, say, it's still possible that that would not fall under statutory rape. But that's going to be a pretty rare exception. Now, some other examples, including this, are incest. So even if you had a 35-year-old sibling or a 50-year-old adult having sex with a 30-year-old child, it's still a sexual act. It's still a forbidden sexual act. It's still a crime. We have sexual harassment. We've got prostitution, where arguably at least both parties are willing. We have voyeurism. We have exhibitionism. Voyeurism is to stare in or peep or watch a sexual or sexualization. Exhibitionism is to provide that. And of course, we've got child pornography. So let's look at this whole issue, probably the most important one here, and that's really going to be the statutory issue. Let's look at statutory rape. And remember, in North Carolina, and we're going to focus here on North Carolina, that, again, we have identical crimes. We've got the rape and the offense. So we're going to have to set an age. And the minimum age of consent in North Carolina is 16. Now, there are some instances where it's higher than that. There are some instances when you can never consent. But North Carolina, again, has identical crimes. We have first-degree statutory rape, first-degree statutory sexual offense. Second-degree rape, second-degree statutory sexual offense. It's never a defense to claim consent. It's not a defense for a 30-year-old predator to say, well, yeah, she was 15, but she consented to the sexual relation. It is not a defense under certain numbers that you're married. So if you were lawfully married at a very young age, below the age of consent in North Carolina, and you were having sex, it is not a defense. Now, the age of consent in North Carolina, below which you cannot have sex, is 16. Now, there is also statutory sexual offense, statutory rape issues, although we don't tend to use the term statutory there. We have other terms we use. There's also a number of terms where there's a relationship. So sexual activity with a student. You have someone, usually a teacher, a principal, someone in the school system who is having sexual relationships with someone in a lower position, a student. Sexual activity by a custodian, that's someone who has charge of a person. I'm not talking about the old definition of custodian, which was a broad definition of janitor. I'm talking about someone who has custody of, control of. Then we've got indecent liberties with a minor in North Carolina, which sometimes those are things that they are sexual, but they're not as obvious. So it could be something like if you French kissed a child. It's not as overt as one of the major sexual offenses or rape, but it's clearly an issue. And then contributing to delinquency of a minor, allowing usually them access or allowing them to do certain things. Now, you notice that most of the time there's a power dynamic here. There is a person with a lot of power and a person with almost no power. And what the law is worried about there is, since one person has all the power here, they could always claim, well, look, this person consented. Well, no, they didn't really have a choice to consent. So we put the law in to protect those people. All right, let's look at some of the elements of rape, and some of this is a development of the common law, comes out of it, and some of it is changed. So again, if we go back to the bad old days, and I don't think there's any other way to describe how the laws involving around rape were in the bad old days, there was a lot of things like, well, why didn't you resist? You claim you were raped. Why didn't you fight back? And then there was the idea that, men can't be raped. And horrible things like she was asking for it or he really wanted it. So today, many of these historical elements have been abolished. So let's look at some of the things. First thing, rape is gender neutral. So is it possible for a man to rape another man? Is it possible for a woman to rape a man? The answer there is yes. Now, in the past, probably not. Those cases would be rare, if not impossible to bring. And traditionally, we only looked at rape when there was a vaginal penetration, the kind of older definition, the one that North Carolina enshrines in its rape statutes. And most of what North Carolina would talk about in sexual offense, the question would be whether it was rape or not. The next thing that changed is many kinds of coercion, in addition to physical force, create the lack of consent. So in the past, you would see language in case law that would say, oh, well, she didn't really resist. She didn't fight back. She wasn't physically forced into the rape. Now, you don't need a lot of that. Now, we can look at the power dynamic and say, well, this is just so out of skew that, yeah, of course it's a rape. The next thing is you would see these old case laws or these old situations where the person's resistance was only verbal. No, stop. Well, she says no, but she wants it, yes. That, verbal resistance, a no is a no now. Again, in the past, there were instances where the rape wasn't deemed to be a rape unless it was reported. Or if it was corroborated. Someone else had to. They didn't, in the bad old days, you would have people say, well, it's just a he said, she said situation. And, today, no. if someone is raped, the collaboration or corroboration of the rape is sufficient even without another witness. Husband and wife exemptions have been largely removed. Again, this is the idea that even below a certain age, people shouldn't be getting married. The prompt report rule has been relaxed. And the last thing, and this is one of the last things that really came into this bucket of new rules, is rape shield laws. In the past, one of the things that rape victims had to fear was that their past sexual history was going to be put on trial itself. Oh, you claimed you were raped. Well, let's talk about how many sexual partners you've had over your lifetime. Don't you think that's excessive? And the embarrassment and the shame was used as a weapon against a person simply because they had a sexual past. And, of course, that's changed. All right, so let's look at some special rules. One of the things is, once consent is given in North Carolina, no rape occurs if it's withdrawn during the act. So if there's not sufficient time, and this is a difficult thing, if there's not sufficient time, if someone has consented to sex, they're having sex, and at a certain point, the other person changes their mind and one party continues, it's generally not going to be a rape. It can be, by the way, an assault and other things. And there's real questions about how long this is. And frankly, this is almost never going to occur. Statutes are gender neutral. Both men can be raped by other men, by women, and women can be raped by other women and by men. Virginity is not an element. We don't care if you've never had sex or if you've only had sex with one person or if you're married or not married. Now, here's an interesting one. We have a doctrine in North Carolina called the possession of stolen goods. If we have someone who was raped and their purse was stolen, or his wallet was stolen, because it can be neutral. If we catch the rapist, the person we're charging with rapist, in possession of the stolen goods, a rebuttable presumption can be created that that's the rapist. Now, it's not shifting the burden. It's not saying, okay, now you have to prove your innocence, but a presumption existed that you're the person that was in contact with them. Otherwise, explain how you have this stolen wallet, this stolen purse. Also in 1977, we abolished spousal exemptions. One of the things that used to exist in North Carolina law all the way up to 1977 was you could never charge a husband with raping a wife or a wife with raping a husband. You were simply protected if you were married. All right, let's talk about non-consent here. Consent is very often an issue that is brought up in rape, brought up in these sexual assaults in North Carolina. And what is without consent? What does it mean when we're talking about a sexual act without consent? Well, first of all, was it forced or coerced? And, sometimes this is really easy to see. You took a knife, you took a gun, you took an object, and you threatened to beat or kill the other person. That's forced or coerced consent if they didn't consent. Also, sometimes the victim simply doesn't express consent, maybe out of terror. Sometimes the victim is so young that they have no ability to consent. And then we've got issues like roofies where a victim is incapacitated. So they are incapable of giving consent. Now, of course, sometimes it's an innate condition. They lack mental awareness or acuity where they can actually understand what the sexual act is, so they can't consent at all. Sometimes they've been drugged or they're drunk. Now, mistaken consent, again, we're starting to get into areas that are really pretty rare. Excuse me. Okay. Excuse me. Okay. So, because the state has to prove lack of consent, the presence or the absence of consent is very often raised. All you have to do in most jurisdictions is show either that you said no or that you didn't say yes. And this can occur because you just didn't say yes or because you were incapable at any time so that a reasonable person would know that consent is not given. So if anybody uses force or threat of force, even if the person consents, it doesn't matter. It's still going to be rape. Some jurisdictions still require force or threats of force, but really no. Really, the threat of force is where force is still part of the rape requirement. And very often there's enough wiggle room in there where they say threats or fear of force will serve as a substitute. So even in those jurisdictions that I would say are more backward looking, that still have the term force in them, consent is still center stage. In most states, an honest mistake of fact about consent can be a defense, but it is not going to be available for statutory issues and statutory rape issues or crimes like incest. All right, let's talk about one of the last issues that kind of developed around this, and that's the Rape Shield Law. And we'll look at North Carolina's broadly in a minute, but most states, including North Carolina, have rape shield laws. And again, this was to prevent the second trial, where you would be trying the person who committed the rape, but then as a defense, you'd put the rape victim on trial in a certain way. You'd inquire into their past sexual behavior. You'd inquire into their reputation. And one of the things about reputations is they're basically rumors. If you say, pick a famous celebrity, if you say this famous celebrity is like this, he is violent, or she is sexually aggressive, or he's gay, or she's frigid. None of you know that. Unless you actually know that person, you're just basing it off of things you've heard, their reputation. And when we narrow this down to private individuals who aren't, famous, it even becomes shakier ground. So laws have been passed in many states, including North Carolina, to limit how far defense attorneys can inquire into the victim's past sexual life. So if I'm defending a rapist, there are limits on what I can ask the rape victim. Now, I can ask, even under rape shield laws, certain questions. One, were there past sexual relations between the victim and the defendant? Because this really goes to consent. And this is, okay, let's suppose we have Jane as the victim and Jack as the accused, the perpetrator. If Jane was on the stand, as a defense attorney, I would be allowed to ask, in the past, have you had sex with Jack? And I could even ask, after this event, let's suppose the rape supposedly occurred on June 1st. If I could say, on June 15th, did you have consensual sex with Jack after the rape? So you can ask questions about the relationships between the parties if there were consensual relations. The second things you can ask is you can ask about evidence that would show that this particular instance where the claim of rape occurred can be attributed to another party. All right, so again, Jane is our victim, Jack is our accused rapist. The defense attorney would be able to ask, okay, you claim that the rape occurred on June 1st. Did you have sex with, you make up another person, Bill, on that date? I could ask that question because then I could say, all right, well, we did a DNA testing on the semen and it turned out that semen belongs not to Jack, the person on trial, but to Bill. So you could ask those questions. The final area you can usually inquire into, and this is just the broad ones, there are more than these. You could say, have you ever falsely reported rape in the past? That can become admissible because if the person is a habitual liar, then the jury and the judge should know that. All right, so let's look at North Carolina's. Now, the North Carolina rape shield law falls under Rule 412. And basically, I am, as a defense attorney, prohibited from bringing up past sexual history except in these 4 instances. One, and the first one we talked about, that there was consensual relationship between the defendant and the victim. 2, evidence that somebody other than the person on trial committed the rape. 3, that the victim fabricated or invented the sexual act, or evidence of a pattern of consent distinctive and related to the defendant's version of the sexual acts. That there is a pattern of this. And basically, you could show under this 4th one, you claim this was non-consensual. Did you accompany him to a motel? I did. Did you buy lingerie for that night? I did. Did you buy birth control for that night? I did. Okay, that's evidence of a pattern that is distinctive and relates to the idea that this might be consensual. And if the defendant had already testified to that, I could ask those questions. All right, let's look at statutory rape and then how North Carolina looks at it. We have to pick an age. And I know that, in past times, in part because people started families much earlier and had children much earlier, that, certainly men and women were getting married younger and having sex younger. I mean, it's been a while since I read Romeo and Juliet, but as I recall, they were teenagers and quite young. Of course, they're fictitious characters. So a lot of this comes out of us, this kind of murky area where we're trying to decide when is someone an adult. And we have to pick an age. So usually sexual relations with a child under a specific age, and that most common age is 16, is a crime, even if the child, the person under 16, the teenager, consents to it. And generally, it is not a defense that the person having sex with a child believed that that child was old enough. Now, some states allow this. Of course, many states make it worse if you're even younger than 16. So we'll say, okay, well, from 12 to 16 is first-degree statutory rape, and second-degree statutory rape, and under the age of 12, it's even worse. So look how North Carolina has looked at this. We have statutory rape of a child. Now, one of the things that goes on in North Carolina is we look at delta, and that is the difference in age between the rapist and the rape victim. So if 2 teenagers, a 15-year-old has sex with a 14-year-old, generally the delta isn't big enough there that we're going to charge statutory rape. It only becomes a crime, you'll notice, when it is 4 years or 6 years, depending. So let me explain that. First-degree statutory rape is charged when a child is under 13 and is at least 4 years younger than the defendant. So if you had a 12-year-old having sex with a 13-year-old, it's not first-degree statutory rape. But if you had a 12-year-old having sex with a 17-year-old, it's first-degree statutory rape. Then we have statutory rape of a person who's 15 years old or younger, a child under 15, and at least 4 years younger than the defendant. If the delta is 6 years, it's worse, but if it's 4 years, it's not as bad. And basically what we're saying here is the greater the difference in age between the parties, the worse the crime is. And then we have sexual activity by a substitute parent and or a custodian. And again, that's just someone in charge. We have incest. Now, it's estimated that somewhere between 60 and 100,000 female children are sexually abused annually in the United States, and that only about 20% of these attacks are reported. It is believed that it affects about 10% of families, with at least 5,000 cases of father-to-daughter incest. And even though, yes, this can occur mother to son, mother to daughter, father to son, by far, and the numbers are very murky, it's father to daughter. The crime of incest may be committed by adults within a family, but the public concern and prosecution are generally involving the children. So like statutory rape, it doesn't require that a threat was used or that there was consent. But you do have to prove there is a relationship there. So let's look at the crimes in North Carolina, the North Carolina incest laws. There's North Carolina General Statute 14178A. This covers carnal intercourse between these relatives. Grandparent to grandchild, so you notice that's neutral. Parent to child or stepchild or adopted child. Brother or sister, aunt or uncle to niece or nephew. And we make it more serious if the child's under 16. It doesn't matter if the child, again, is 25 and the parent is 50, it's still a crime in North Carolina. But we make it more serious more serious in its penalty if the child's under 16. Okay, so most commonly abused, the father abuses the daughter, then it's siblings, brothers typically abusing sisters. We are guessing that the total number that has occurred or occurs is somewhere around 4 million. 80% of the victims are females, only 10% of the perpetrators. So it's about a 9-to-1 ratio. And here's the frightening thing. About a quarter of the female victims will become pregnant by the family member. 1 in 9 girls and 1 in 53 boys are victims of this. All right. Let's talk a little bit about sexually transmitted diseases. During the AIDS epidemic of the 1980s and 90s, there was this fear that AIDS would be weaponized and that people would get AIDS, both in these sexual assaults, and that it could be used as a weapon against people. So every state pretty much enacted specific laws to deal with this. If you know you're HIV positive or you know you have an STD and you knowingly or recklessly or negligently expose another or infect another person, it becomes a felony. Something else that happened in the 1990s was the rise of the sex offender registry. And this comes out of something called Megan's Law, named after a girl who was a victim of a sex offender. The sex offender registry is available for anyone to read on the internet, and it requires that those convicted of whatever the state decides is a designated sexual offense, and that can range all the way from the worst of the worst, the first-degree rape or the first-degree sexual offense, to indecent exposure, all the way down to the less serious crimes. We're going to require those people to register in their city, their county, give the street where they are, and to tell us where they're working and where they're living. Now, initially, it was just going to be rapists and people who committed these sexual faults. But as I said, this has been pushed down to cover almost everybody. You're required to provide DNA samples so that if a rape does occur and we get a DNA sample out of it, we can trace it back to you. You're required to avoid working at or with vulnerable populations. So if you have a conviction for a sexual assault on a child, you can't work in a school. Neither can you even live near a school very often. So the North Carolina Sex Offender Registry basically lasts 30 years. You can, if you're good, petition to be removed after 10, but it's difficult. If you come into North Carolina, you have to register. North Carolina lets anybody search this registry. And if you don't put your name on it, if you're a sex offender, you're committing another crime. It's a Class F felony. All right, so a little bit about civil commitment and criminal confinement. In some states, this is not done that much in North Carolina, but in some states, you're permitted to get a civil conviction of sex offenders if you get out of prison. So someone gets out of prison for molestation of a child, you then go and you try to get them civilly committed to a mental institution. It's only going to be permissible if you can show that they pose a substantial threat to the community in the future and that they're incapable of controlling their behavior. So as I said, you don't see this a lot. So North Carolina Violent Predator Control and Treatment Act. North Carolina can, under North Carolina General Statute 14-20820, declare someone an SVP, a sexually violent predator. Then we bring in expert testimony to show that they're likely to engage in future acts of sexual violence. And at this point, we can try to civilly commit them. All right, let's talk about prostitution a little bit. Every state, but Nevada, makes prostitution a crime. Now, Nevada makes it a crime in certain counties, but there are exemptions. So prostitution includes the following: having sexual relations with another person for a fee or something of value, or soliciting to engage in sexual relations, or requesting. Now, in North Carolina, we tend to use the term assignation. Pandering is a charge brought against a person who entices another to become a prostitute or maintain a prostitution. Pimping would be the common one. In many states, it's a crime called debauching a minor. We don't have this in North Carolina, but some states do. To entice a person under a certain age to have sex with a prostitute. We have a criminal statute for that, but we don't call it debauching a minor. So North Carolina laws on prostitution. North Carolina General Statute 14-203 establishes the crime of prostitution. Now, the interesting thing in North Carolina is it seemingly only covers sexual intercourse for hire. But since that is I'll explain that, but basically it seems to only cover that. Assignation is the charge against the party who makes the appointment for prostitution. So if you have the John, the person who's buying the prostitute, he's committing assignation. North Carolina has a number of crimes. We have the solicitation or procuring for prostitution. We have maintaining a place of prostitution, and we have loitering for prostitution. Now, it is a more serious crime if you're involving minors. And you'll notice that these are Class C felonies, the first two. Facilitating a minor's prostitution, where you entice, encourage, or facilitate a minor, or you supervise or support a minor, or participating in the prostitution of a minor, you buy a minor for sex. It's a Class F felony. All right. Other sexual acts, sexual contact without penetration, can still be a crime. And usually what we have in North Carolina is we have a number of acts. One of the terminology you frequently see is lewd and or lascivious conduct or behavior. So if you're having some sort of contact to arouse or gratify either the child's sexual desire or their own. Let's look at North Carolina law to make that a little clearer. We have indecent liberty with a child, where you have some sort of sexualized conduct with the child, and there is a difference in age of at least 5 years. If you commit a lewd or lascivious act, and it does not have to be an unnatural act. Kissing a child in a sexual manner is covered under lewd and lascivious. It's indecent liberties with a minor. And it's a Class F felony, so you're looking at, conceivably, depending upon past criminal acts, you're looking at, a couple of years in prison. Protecting children against sexual exploitation. These are going to be all the acts against child pornography. Now, child pornography is treated differently than adult pornography. Adult is openly sold. So you can buy, at least in the past, you can buy old magazines like Playboy or Penthouse. And currently on the internet, you can go to websites and you can see things involving involving adults. But unlike adult pornography, child pornography, we don't even get into the question, is it obscene? Now, you can ban obscene adult pornography. If I made something like a snuff film where someone was killed or there was a depiction of something that is deemed to be obscene, such as bestiality, you can ban that. But we don't even have to worry about obscene. The mere fact a child is involved is enough to make it not protected speech. Possession, production, or sale, usually called trafficking, or solicitation of child pornography is by itself a crime. Let's look at North Carolina law. So North Carolina makes any participation of a child in it a Class C felony, something you're looking at a decade plus years in prison. It is second-degree sexual exploitation to record a child, distribute a child's pornography, transport, receive, or sell same, and just simple possession, just having it, if we can't show that you received it or sold it, is third degree. And one of the things about this, like all the statutory rapes, it is not a defense to say, I didn't realize the person in the film or in the video that I was watching was underage. Prosecution has increased dramatically. Why? Because we have the internet. The anonymity the internet promised is not complete, and people will share all sorts of things on the internet. So prosecution under federal statutes have been somewhat complicated by evolving internet and computer technology. And the reason for this is, I guess it's easier to hide. It's easier to distribute. In the past, if someone was going to make child pornography, you would have to hire the children or coerce the children into it, film the children, produce the film, distribute the film, sell the film from the distributors, and then possess it. And now it's just a click. Okay, so let's talk about pornography and prostitution. What about the producers of X-rated videos and films? Are they engaged in the business of prostitution? So the argument ran that if an actor is being paid to have sex, that's just like a prostitute being paid to have sex. And we have the case of California versus Freeman, where Freeman was convicted of pandering for hiring adults to perform sex acts, filming those sex acts, and selling the video. Went up to the Supreme Court said no. Hiring actors, adult actors, to perform sex acts to be filmed in a private place is not procuring for prostitution. Voyeurisms. Until recently, peeping toms were very often charged with things like disorderly conduct. But now a lot of states, and North Carolina's got some examples of this, have voyeurism or invasion of privacy laws in their criminal codes. And these, in fact, have been toughened up in part because it's so much easier now to film people. Where in the past, if you're thinking about an invasion of privacy where you're going to make a recorded record, you'd need these big, bulky cameras. Now people have their phones. So we have specific statutes to prevent things like upskirting, which would be placing a device underneath typically a woman who's wearing a skirt or a dress to look up to see their genitalia, or down blousing, which would be to look into a woman's dress from the top to see her breasts. So North Carolina has our peeping Tom statutes. It is a crime to peep into a room occupied by another if you do it intentionally as an invasion of privacy. And if you record this, if you use technology to do it, or if you make a recording, it's a separate charge in North Carolina. All right, final point to talk about here before I let you go is North Carolina crime against nature. North Carolina 14-177 makes crime against nature a criminal act. In fact, it makes it a felony. Now, if you recall, when I was talking about prostitution in North Carolina, I told you prostitution is only vaginal intercourse. It doesn't cover all the other things you think about. And those examples would be fellatio, cunnilingus, or analingus, most commonly. So you might think, well, then if a prostitute gets arrested and he or she was only going to perform fellatio, was only going to have oral sex, then they could claim, hey, you can't arrest me for prostitution because I was doing this. Now, they can't do that, or they shouldn't do that, and this is why. Prostitution in North Carolina, at its bare bones, is a misdemeanor. Crime against nature is a Class I felony. So if you said, yes, I was going to perform fellatio, but it doesn't fit the definition of prostitution, congratulations, you've avoided a charge that is a misdemeanor, but you have then admitted to a charge that is a felony. Now, the Crime Against Nature statute in North Carolina, which makes those three broad categories of behavior crimes, seems to only be triggered if there is a lack of consent, if minors are involved, if it is coercive in some way, if it is done in public, or finally, if there is some issue of prostitution. Okay, this was a difficult unit, I'm sure, for some of you to go through. I hope no one had an issue with it, but it is something we have to study to understand the criminal laws. All right, whenever you're ready, we can go on to the next, which will not be quite as fraught with these explosive issues. Have a good morning, afternoon, or evening. I'll see you with the next chapter.